May I please, your lordship, my lord, with the consent of the other side, my lord, I beg to mention item number 3 and 4, my lord. We have some difficulties today, my lord. Can it be taken on 12th of June
Your fault.
for the respondent FCI, my lord?
I'm for the petitioner on less than 59.
Any objection?
No,
Was paid for by the Learned Standing Council FCI and not objected to by the other side. This is the matter on 12th of June.
Deeply object.
They will.
May
3
I,
and 4.
may I please, your lordship?
Yes,
Beg to mention for IA in civil, lordship, it is a review petition and the review is of your lordship order.
okay,
Kindly to meet the matter on tomorrow, lordship, it's very urgent.
okay.
Lordship, I beg to mention item 15 of today's daily list. Item 15, Lordship. This matter, we needed to file a reply, Lordship, but the petitioners were posted outside this station, Lordship. So they could not come, Lordship. I pray that this sometime may be granted for filing that reply, Lordship.
How much time?
3 weeks, Lordship.
All right, that's paid for by Mr. MP Sharma, Learned Council for the petitioners. Further 3 weeks time is granted for filing a joint affidavit.
One more thing, Lordship, in respect to item 12, Lordship.
Hmm.
Herein, Lordship, we tried to communicate, but we could not, but then we have received some from the bar itself, Lordship, some information that the petitioner is no more, Lordship, and so we could not communicate, Lordship, and if a notice could have been issued, Lordship, then from this court, Lordship, I think that would have been helpful.
But you are the council, isn't it?
We tried, Lordship, we could not communicate. Otherwise, Lordship,
How did you try?
over phone as well as by letter in the address, Lordship.
By writing letter?
Yes, Lordship.
What is to be done?
Nothing.
Let us see that file, item 12. How do you know that he has expired?
Lordship, the respondents, they were interested, Lordship. Otherwise, the respondents were interested. On the last occasion, also they said that he had expired, Lordship. And he do not have any legal hair also, Lordship.
What is the issue regarding?
Was relating to promotion, Lordship.
Hmm,
Promotion.
Promotion.
A review DPC was to be convened and there were subsequent litigation, prior litigations, Lordship.
Oops, Saranya, where is this place?
Let it reach, Lordship. Let it reach otherwise, Lordship.
Where is this place? Oops, Saranya. It's in Guwahati.
Yes, yes, Lordship. It's in what?
Please write down Mr. M. Sharma, Learned Counsel for the petitioner submits that he has not been able to contact the petitioner despite all effort. He further submits that he has also been informed through the private respondent
Yes, Lordship.
that the petition is no more. Now, considering the submission, registry shall issue notice to the petitioner by post in the address given in the first title. By way of registered AD. Mr. MP Sharma, Learned Counsel shall also do the same
Lordship.
and submit an affidavit regarding the steps taken by him within 10 days. list the matter again after 3 weeks. Along with appropriate note about the steps taken in this regard as directed herein above.
Obliged, Lordship.
May I please, your lordship?
Yes,
My lord, item number 8, my lord. My lord, this matter may be adjourned for 2 weeks, lordship. As earlier lordship, lordship says of Honorable Justice Nair was the council lordship, and the newly engaged council AMS Majumdar lordship, he could not able to appear today lordship due to some his family problem lordship. Someone from his family died lordship.
okay, on the prayer made on behalf of Mr. AMS Majumdar, learned counsel for the petitioners, and not objected to by the other side, matter stands adjourned for 2 weeks. All right.
Obligation.
Have you responded in the Lordship? In item 2, I appear, Lordship.
Good master. Just follow Jamada. Item 2. Yes. 1 year not there.
No.
Item 1 you're not there.
Item number 1, last 2 occasion, nobody appears, my lord.
Lordship, in this matter, the advertisement is of 2011.
No, sir.
Leads to a selection process, Lordship.
Number 2.
Now, Lordship. Hearing the respondent number 4, 5,
One to say.
and 6.
One to say. One to say.
And Mr. A. Chakraborty had appeared in item 1.
He appeared in item 2 only, Lord.
He 2 only. A Sakobody for 2, my lord.
Hmm?
A Sakobody for item number 2, my lord.
2, but the order is recorded here. It's
There
a
is
common
It's
order,
a common order for both the cases, my lord.
common order.
Common order.
Why is clubbed together?
Club together, my. Same recruitment process, my lord. Same selection. Same recruitment process, same selection, my lord. They are unsuccessful candidate, my lord. Petition number, item number 1 also and 2 also. Actually, in fact, my lord, last but one order, your lordship kindly see. That was on that order, and that day, my lord, nobody appears in both, my lord. That's why it was posted for, it should be posted for dismissal order for dismissal. In that one, in that day, my lord, appearing on behalf of item number 2, my lord.
Oh, we'll dismiss it then.
For
What to
item
do?
1,
Item 1.
my lord.
Please write none appears for the petitioner when the matter is called. The matter stands dismissed. No. When the matter is called. Stop. Same was the case when the matter was listed on 20/2/2025. And thereafter on 23/2025.
Private respondent application.
Stop in view of above, the
This one is the same. This one is the same.
case is dismissed for non-prosecution.
Women evaluation.
Okay, thank you.
He open no way.
This is homework.
Yeah, from Palakis.
Let the case be detached from WPC number 7397 of 2013. Okay. Now in item 2,
Lordship, it relates to a selection process which was initiated by advertisement dated 5/11/2011. Lordship. Now.
cause of action survives. cause of action survives.
It's a big question, Lords.
Big question. 2018, some
And that was 2013, my lord.
petition also is in cartridge paper,
Lordship, yes.
legal size paper, 2018.
Yes, at that point of time, it was, my lord.
But then Lordship, my argument would be Lordship. Simple argument, Lordship.
Mm.
There were 37 posts advertised, Lordship.
Mm.
And we filed an additional affidavit. Therein we said that Lordship, we obtained answer sheets through RTI.
No,
And-
37 post is what post?
Lordship,
What post?
post of class 1, grade 3 cadre of Assam Finance Service, Lordship.
Class 1.
Class 1, grade 3 cadre.
Class 1, grade 3.
Lordship.
Class 1 is again further
Treasury officer.
classified.
It's a treasury officer.
Class 1 is again classified into grade 3.
Yes, yes, Lordship.
Class 1, grade 3. Assam?
Assam Finance Service, Lordship.
Okay, Assam Finance Service. What is the name of the post? TO,
PO.
Treasury Officer.
Yes, Lordship.
So 37 posts was advertised. You appeared for that post. I mean, you applied for the post.
We appeared and we cleared the written examination. Subsequently, Lordship, interview was held
Hmm.
and we could not clear that, Lordship,
Interview.
interview, Lordship.
So what is your case then? That
Lordship,
you were not given appropriate marks in the interview?
in the additional affidavit, we have said that, Lordship, not in the interview, but also in the written examination.
Hmm.
My marks would have, Lordship, increased. And we have stated therein, in the additional affidavit, that 10 posts were lying vacant, Lordship. And apart from this 37.
No. What do you mean posts were lying vacant? See, posts may be lying vacant, but the thing is that whether you qualified or not.
Yes, that's what, Lordship. We made some allegations of,
No, even if you don't qualify in the interview, if posts are lying vacant, you should be appointed like that.
not like that, Lordship,
Then?
but we preferred a representation wherein we stated categorically that some cash for job scam was brought to the notice of public by news channels and all. That's at page 117, Lordship. And there were anomalies with regard to the allotment of the reserve post. Lordship. 117, Lordship.
117. Scam. Mr.
But-
Sharma, where are you traveling from? You're traveling from that 37 post. You have gone through the written test, but somehow failed in their interview.
Lordship.
Then you say there are some posts vacant.
Yes,
Then
yes.
now you say there was a scam.
Actually, my challenge.
You're
was
traveling
also-
everywhere. I don't know how, what.
I challenge the appointment of the private respondents, Lordship.
Mm.
Stating these things, Lordship, basically, which are at page 117, Lordship.
Page 117.
Yes, Lordship.
Who has written this letter?
It was written by the petitioners only. Apart from the petitioners, some other person.
How many petitioners are there? 51.
There are
51.
six petitioners.
petitions.
Huh?
There were six.
Six petitioners, Lordship.
Oh, 6 petitioners.
51 respondents are there.
31 respond, 35, 37 private account.
That's, 44 respondents.
Because the file cover reads like this, Abhina, Pukan and 50 others. Anyway, there are 6 petitioners,
Yes, yes.
6 petitioners and
Clear.
44 respondents.
Lordship.
Let us come to the advertisement first, one by
Lordship.
one.
Now, Lordship, since my submission is that, Lordship, since considerable time has passed and There are 7 posts lying vacant apparently, Your Lordship. That is not denied. Now, this selection probably has splendid force, Lordship, and new selection needs to be done as per the recent laws, Lordship. So I would pray that some preference be given to us and our age, if necessary, be condoned with regard to participation, our participation in that process whenever it is held. Lordship.
Your prayer is to set aside the selection process.
Yes, Lordship.
And direct the respondents to undertake fresh selection process.
That was there, Lordship.
Then interim was to stay the select list. Any interim order passed in your favor? No interim order. Select list is of the year 2013.
I know that, Lordship.
We are in 2025.
Even he succeed, he will not get anything. My lord.
Uh-huh.
He's now simple pair is that about the correction man. He says that my lord, already we have already over age. So our case may be considered by condoning the age, my lord. I may be allowed to appear in the subsequent election, subsequent my lord selection. But that can be done by the government only. I
Mm.
cannot, because I am representing APSC. APSC
Government,
can only, my lord.
you're there?
He can file an application as per law.
We can make an observation
My lord.
and not a direction, but an observation that in the event they apply, the petitioners seek for age condonation, the same may be
As
considered.
well as some
Sympathy.
preference in the appointment.
But what preference?
Because we
No,
qualified in the written test, Lordship. and-
maybe,
Yes, Lordship, and we pointed out certain elements.
see, UPSC exams, every year they are sitting for exams. Last to last year, you qualified in the written preliminary examination. Can you say that I should be given preference in the next exam? It cannot be. Every exam will have its own thing. You cannot carry forward your merit of that exam in the next exam. They'll be asking too much, Mr. Sharma. But for age condonation, I can make an observation
Lordship.
that if you apply for
Yes,
that, that may be considered by the respondent parties. We'll dispose it of like that.
Lordship.
Please write down, heard Mr. MP Sharma.
Lordship will not record it as my submission, Lordship. Just simply Lordship will observe it, Lordship.
Then why should I show my enthusiasm to give you some more relief, which you have not even asked for? Huh?
Lordship will record it.
Okay. Heard Mr. MP Sharma, learned counsel for the petitioners. And Mr. Mahanta, TJ Mahanta,
Yes, yes.
learned standing counsel, APSC,
APSC.
Who
For
else?
response number
P.
3.
Sharma, Lordship, assisting.
assisted by Ms. P. Sharma, learned counsel. Sorry, your name and also Mr. S.A. Patiar. S.A. Patiar. Spelling, please give in writing. Mr. S.S. so-and-so, learned counsel appearing for respondent number 41. Stop considering the facts and circumstance involved in the instant case. The matter is taken up for disposal today. Stop, the case of the petitioners is that they participated in the selection process for 37 posts of Class 1, Grade 3 cadre of the Assam Finance Service. Which was advertised to be filled up. White advertisement dated 5/11/2011. To stop. According to the petitioners, they were successful in the written examination that was conducted. But however, they have failed to secure the required merit in the interview, and for which reason they have not been selected for the said post.
And Lordship record one more thing, Lordship. Herein the respondent number 4, 5, and 6 were subsequently convicted in a case with regard to the jobs for scams, Lordship. And in this case also, we allege the same thing, Lordship. So there is
According to the petitioners, the respondent numbers
5 and 6.
4, 5, and 6, who were selected for the post in
No, no.
question.
They are chairman of.
I'm sorry. 4, 5, and 6, who are the authorities who had, who were instrumental in the selection process, have subsequently been convicted
Oh, yes,
Uh,
5, 6, Namek.
on a criminal case that was registered due to the cash for job scam. Stop. Therefore, the petitioners contend that there was serious anomalies and irregularities in the selection that was made for the posts in question. Stop. This apart, a number of vacancies had also occurred in which the petitioners can easily be accommodated. Full stop. It may, however, be seen that the advertisement is of the year 2011 and the select list being challenged is that of 27/11/2013. To stop, this court, apart from issuing notice of motion, had not granted any interim stay. Stop. Admittedly, much water has flown since the issuance of the impugned select list. To stop, it is also submitted at the bar that any subsequent selection has happened.
I don't.
Mr. Mahanta, any selection?
I don't know because like this department might.
Okay, then we leave it out.
Department can.
Okay,
In the affidavit, we have to at least 10 posts were vacant at that point of time. That Lordship will.
considering the long lapse of time, this court is of the view that no effective relief will be possible to be given to the petitioners at this stage. Stop. Mr. MP Sharma, learned counsel for the petitioners at this stage, submits that the petitioners admittedly have by now become over age for seeking government employment. And therefore, court may direct the respondent authorities to condone the age of the petitioners in the event they apply for any government job of similar nature so that they can participate in the selection process. To stop considering the submissions made and upon perusal of the materials available on record, the writ petition is disposed of with an observation that in the event the petition is apply for government jobs of similar nature and in the meantime have become overage, they may submit suitable applications seeking conversion of age to participate in such process. Stop in the event such application is submitted, the respondent authorities shall give due consideration of the same. To enable the petitioners participate in the selection process. With the above observation, the writ petition stands disposed of.
That was hard and the record was called for. And record was placed before the honorable judge.
Hmm?
Fact is that, my lord, what is the fact of the petitioner? He was a constable in some reference. And he rifleman. His fact is that he was brutally beaten, he was hospitalized, and some documents has been signed under force threat, and that document has been applied to show that he has resigned from service. This is his fact. And my lord, the record has come. From the record, they have produced that the resignation letter, he has submitted a resignation letter. His fact is otherwise. So, my lord, it is an appreciation of fact. Lordship may produce the record and decide the matter.
See, matter was heard by different bench.
My lord.
So I cannot automatically
Yes.
visualize what had been argued on that
Yes.
court. So you are required to at least give me the basic facts.
Yes, fact is that, my lord,
Not straight away say that record has come, you decide.
yes, yes.
Okay.
The page number 11, this is a, my lord, the order of discharge.
Just a minute. Please read the synopsis.
Page 12,
Synopsis.
synopsis.
Please read it.
My lord, he was forcefully discharged from service from Assam Rifles as rifleman GD with effect from 1/10/2013 while working at 30 Assam Rifles. He is agreed with the improved discharge certificate at Annexure 1. Submitted his appeal on 18/11/2013 to the Director General Assam Rifles stating that he was beaten by the commanding officer Colonel Betpal Yadav and hospitalized. His signature in blank papers and discharge certificate was forcefully taken under threat. Petitioner requested for his reinstatement in service. The DGR file is impinned letter dated 11/3/2014 without scrutiny of the records and without inquiry into the claim of the petitioner that his signature was collected forcefully has rejected the appeal of the petitioner. Petitioner never submitted any application for his voluntary discharge from service, rather his signature was collected under threat and coercion at the dictation of the commanding officer Colonel Betpal Yadav. Petitioner was removed from service in the guise of the discharge from service at his own request in a planned and systematic manner. This is my synopsis. Now, my lord, I am coming to
You have been discharged.
discharge. And the discharge certificate says at his own request.
Discharged at your own request.
Own request, page 12.
How many years you've served?
Initially he joined Melod on 2009. And after servicing 4 years, 4 months, he has been discharged.
After being discharged, what is the benefit you get?
I
Any
get
benefit?
nothing,
No benefit.
no benefit.
Where is the discharge order?
This my lord starts at page 11 and 11 page is page 12. Date of discharge 1 October 2013.
And when did you file this writ petition?
Writ petition filed 2014. After my appeal was rejected. Page 16 is the order of the appellate authority. After that, I have approached this honorable court.
16.
Page 16.
Discharge is given by whom?
Discharge has been given by the my lord,
Commandant.
command. That is my lord, my appeal, page 15. That he has stated.
Just a minute, just a minute.
Page 15. I number one so and so have the honor to inform you that I was enrolled into Assam Rifles on 15 May 2009. After completion of successful basic training, I have been posted at 10th Battalion Assam Rifles. During my service period, I always served my duties faithfully. That's why I came on leave during September and October 2012. In the prevailing situation in Garo Hills at present, I was compelled to bring my family to my unit without prior permission of the higher authority. That's why this is a blunder mistake of a young soldier. Major S.M. Bhutia and my colonel, Petrokas Jadhav, gave me heavy punishment in which I had to admit it into hospital, Assam Rifles Nodal Hospital, Muntupuri. Discharge slip number 4/2013 dated 16/4/13 is enclosed herein. Thereafter, they compelled me to sign the discharge application and send me discharge from service. Honorable sir, this is the best you are faithful Joan. I am very much young, no other source of income now to maintain my family. Day by day, my physical and mental condition is deteriorating. In view of that, I request you, sir, kindly allow me to join service for commanding and thus oblige. Page 16 is the order of the appellate authority of 11 March 2014. There are two.
Page 16.
Page 16. There are two. Your case for reinstatement into service has been examined in detail and found that you are proceeded on voluntary discharge. The case does not merit for consideration, hence rejected for reinstatement being period of absence from duty of discharge is more than 5 months. Now, questioning Ebang, we have also rendered certificate that at later stage I shall not change my mind for withdrawal of cancellation of discharge copy at all. This copy has not been served to me. However, they may be in record. They have produced in record. So, my lord, their reply, they have filed my categorical statement. Lordship may kind to page 10, page 8, para 10. Page 8, para 10 of the writ petition.
Page 8, para 10. Yes.
That the petitioner states that illegal act of Colonel Bedprokas OC has compelled the petitioner to put his signature on blank papers, which was later on used by the Colonel Bedprokas as an application of the petitioner for discharge from service. The petitioner is removed from service in the guise of a discharge from service at his own request in a planned and systematic manner. Malice on the part of Colonel Bedprokas as explicit, no rule and procedure established by law has been followed to discharge the petitioner from service. Whether he has been discharged from service with a malicious intention under the threat and coercion by Colonel Bedprokas officer commanding, which is not permissible under law. As such, the petitioner Colonel Bedprokas as party respondent number 4. Petitioner humbly placed before the honorable court to call for the record discharge of the petitioner from service, and after perusal of the record, the honorable will please to set aside and coerce the discharge of the petitioner from service. Now, my lord, in reply, they have produced my hospitalization slip, and that hospitalization support that at that period of time I was under for 12 days under Assam Rifles Hospital, and my contention that I was brutally beaten. Gather supports from this, they are the hospital record they have produced. That 12 days I was in hospital. So, my lord, in such a situation, it is they have taken my blank paper signature and used systematically to make my discharge certificate, and at his own request. So handwriting of these papers are not mine. They have of their own, they have filled up those documents. Take up admission in hospital on 5/4/2013.
Where is your application for discharge?
My lord, I have not submitted any application.
Have they annexed it in the counter affidavit?
Counter affidavit, they have not annexed my application.
We have filed also one additional affidavit matter. That is, also was pleased to bring on record matter. That's why, we have filed an affidavit matter where it is the petition
The additional affidavit for what?
matter.
For what?
Matter, here, matter.
No, what is the purpose of bringing additional affidavit? Any-
Lordship was, to bring on record, my lord, the, application and the petition I have filed for discharge, my lord.
You have made so much of statements in paragraph 4 of your counter affidavit.
My lord, our
But
case, our
In
case,
support of your paragraph number 4,
my lord,
any document,
my lord. Paragraph 4(7), my.
what is happening? Some distortion. No, see, he says that I never applied for. I was under duress. I was made to sign blank paper. In your affidavit in paragraph 4, you have categorically stated that we have given him counseling and all that. In spite of that, he wanted to get discharged. But there is no document to support your statement. We will come to the record. Before that, you were stating something about additional affidavit. Where is that? You file additional affidavit. That's in Hindi. 47, yes. You're going backwards. From 48, you're going back to 47. You should have shown me 47 straight away. Some infiltration from across the border. And they were trying to encroach upon your land. So since you have to look after your land and your family, you want to be discharged. So you gain the signature. This is what it says. I don't know. How do we decide whose handwriting it is? Annexure 2. Page. Yes. Hmm. Hmm.
Before the appeal matter, the director general Assam Police matter, another service, another matter is there. He said that I think within so I was compelled to bring my family to my unit without prior permission of higher authorities. That's why this is another mistake as per his soldier. So and so gave me heavy punishment as I had admitted to Assam. Here is stand is different. Not again, here is some matter. Again, there is some matter. There are three matters. There are three matters.
Yes.
Yes, three matters. Here is. That are these are stated also while I was we must have a technical clear. Now, while that of picture or clear, you must start and finish after of time. By the six of the full of the mother of every what is the issue of the picture? Started editing in a picture and started that is very good. He said it was they have taken this and
One of you submit. Okay. One of you submit. Don't have that question and answer round. Where's that 5-3? Admission in 5-3, where is that? Oh, you just said he was beaten on 3-4, but admitted on 5-3. So then it figures if he was beaten up on 3-4, then he could have been admitted on 5-4. What is wrong in that? Show me the statement or document where it says that he was admitted on this date. Where's that? 16-4. Yeah. Wherein he says that he has been admitted. Oh, this is discharge. But what is the date of admission? From where you're saying that 5-4? For T1. That's the last page of the affidavit. Discharge slip. Date of admission 5-4. Huh. So it figures if he was beaten up on 3-4, definitely he would have been admitted thereafter only. We don't know. We don't know. You see, we cannot start visualizing what happened there. He says I was admitted because of that. So please, present what is your case, that's all. Don't go everywhere here and there because discharge. When? Give me that particular stand taken by you, where? Yeah, generalized body ache. Generalized body ache. Reason of was the incident which happened in the night duty on 3/4/2013. After midnight, your duty was till 2 a.m. You entered the house of somebody else. Hmm. Because of that commotion, you were beaten up and hospitalized. Then discharged from 110. Now, what is the sequence? You see, we have got the date of appointment, then the night duty is there, then the admission to the hospital is there, then discharge is there, appeal before the DGR is there, then rejection of appeal is there. Now, between this discharge from the hospital, 16/4/2013, till his discharge from service, what happened? Hmm? Mhm. Between 16/4/2013 to 1/10/2013, what happened? What happened? No, you tell us. When? When leave was, what is the leave period?
Wasn't happening, madam.
21/5/2030. 38. From where you're saying that? 2020 of the affidavit. Where's that 20 and 20? 20. Petitioner avail leave from 21/5. And from 3. No, when did he submit his okay, application for discharge? No, there is the record. See, that the one which is written in Hindi. What is the date? 16 May. Board of? Hmm. Which one? Page? See, 16 May is the application for discharge. And same date, 16 May is also another undertaking that he will not change his mind. Now, these are at page 47, 49. And the date is 16 May. And discharge happened only on 1st of October 2013. So between 16 May and October 1st, what happened? No. No, there's also statements which says that you were on leave. That is from 21st of May to 7th of June. Then thereafter on from 3rd of August to 30th of August. Where is the statement that it was taken on blank paper, your signature? Statement at paragraph number? Hmm? Paragraph number? Where? What is your explanation on the contradiction? First of all, you say that you knocked the door of somebody else's house. his wife was there, and some commotion happened, which led to you being beaten up by the authorities. And in your appeal, you say that you were so compelled to bring your family without, just a minute, without prior permission. And for this reason, you were given heavy punishment. Now, how do you reconcile these two different stories? You were, okay, beaten part is one thing, but why you do two different story? Yes. So beating happened because of what? He was beaten up because of what? Because of knocking at the door or because of bringing his family? Which one? Then why did you not mention that in your appeal? Then? Because there's no consistency. That is there. Mr. CGC, page 47, application for voluntary retirement is the translation. Page 48 is the vernacular. Okay. The date is 16 May. Now the records which you're giving me, this is also another prayer for discharge, dated 16 May. But the format is different.
Again, here,
It's the same date. It's the same date. No, how many applications he has made in one day? Annexure A, page 47 of the counter affidavit. This is counter affidavit, isn't it? So this is additional affidavit. Yes. The annexure to the additional affidavit, this is application purportedly to have been submitted by the petitioner for being discharged, dated 16 May 2013. Your record which you have given me again is also 16 May 2013. But this is different. It's not same. And it's written in English, not vernacular. So how many applications was made on one day? Why?
then he again said the partner. Again,
So again, one more letter. So resignation letter comes on 16 May. One is written in Hindi, one is written in English. I'm not talking about the translation. This is a separate resignation, which is not there in the writ petition. What was the necessity to write two resignation letters?
Council by the authority, madam. That you will not get any building flat.
Hmm.
That madam. Then
Okay.
consistent, madam. Then he again find, madam.
Now, who has written this? He has not done this on his own. It's typed out. This is typed out. This is typed out. No, you please explain. Application for voluntary retirement. And this one is prayer for discharge from service at my own request. This is, you say, after the counseling. Well, just stop there for a moment. This is regarding CRPF. No. Please understand what I'm talking to. If you don't understand, just wait for your turn. See, the judgment which you're reading, this is regarding CRPF. All right. Mr. Counsel. This is also Assam Rifles, is it? Then why is this mention about CRPF? Because you see, there's some reference about some circular. So that circular has been adopted. Hmm. But in the present case, it is not your case. Because what you are trying to read here is that committee has not come to a finding that he has made the voluntary application for discharge. But here there is no committee. It is not your case that there should have been a committee. You have not submitted. No. That is why you are supposed to make out your case saying that, okay, according to them, I voluntarily applied for discharge. But It cannot be like that. They should first form a committee and the committee should interview me. Then only you have not given that argument. Documents not given to is a different thing. So what is the procedure to be followed for discharge? Counseling is there. Counseling is there. Anyway, what you're relying upon here is something about some committee. You have not whispered anywhere in this writ petition about committee. Yes, please read what you want to read in absence of any material. Para 28. Hmm. Hmm. Yes, anything else? Yes, CGC. Hmm. Please write down. Hard, mister. This is item number. You're Mr. S. Nath. Hard, Mr. S. Nath, learned counsel for the petitioner. And Mr. B. Sharma, learned CGC, appearing for the respondents. By filing this writ petition, the petitioner has challenged the order by which he has been discharged from service on 1/10/2013 from the post of rifleman bracket GD, Assam Rifles. On the ground that he had never sought for being discharged from service. And the same therefore should be set aside. Next para, brief facts of the case is that the petitioner was appointed as a rifleman, bracket GD, under the 30th Battalion, Assam Rifles, on 15/5/2009. So thereafter, he has been serving as such with due diligence. So on 3/4/2013, while he was posted at 30th Battalion, Assam Rifles, Mantri Pukri, Manipur, he was allotted night duty up to 2 a.m. So the petitioner, while returning from his duty, was tired, and due to the darkness, he mistakenly knocked the door of his nearby quarter of one Sri S.C. Das, rifleman, bracket GD. So the wife of Sri S.C. Das opened the door and, without giving any chance to the petitioner to explain himself, started abusing him and shouted on top of her voice. Of the petitioner, being nervous, instead of returning to his quarter, went back to his place of duty. To stop on 3/4/2013. Anyone appearing for this respondent number 4? CO? This respondent number 4, who was the commandant of the unit, called the petitioner to his chamber and, without making any inquiry about the incident, started abusing him. Started abusing and started beating and abusing him. So one Major PM Tangode along with 3 other junior commissioned officers and also 2 other personnel joined the commandant. So all of them beat up the petitioner mercilessly, and for which the petitioner sustained injuries and fell unconscious. He was taken to the Assam Rifles Unit Hospital and was hospitalized for 12 days. Stop. While the petitioner was in the hospital, the quartermaster of the unit, under the dictation of the commandant, met the petitioner and told him that the discharge papers was ready and asked him to sign it. Stop. When the petitioner refused, the quartermaster threatened him at gunpoint and thereafter took his signatures in some blank papers and also in the already filled up form. Stop. The petitioner was not allowed to look into the papers to see the contents. Next para. The petitioner was thereafter set free in the month of May 2013. And he tried to meet the Inspector General, bracket South, to disclose the entire incident. But he was not permitted by the security deployed in the premise of the IG bracket South. So the petitioner was kept under close scrutiny by the close security, not scrutiny, was kept under close security by the commandant of the unit. And subsequently, on 30/9/2013, the commandant called the petitioner in his chamber and told him to meet one Pawan, Mr. Pawan at Guwahati, and gave his phone number. Stop. He also informed him, the petitioner, that he has been discharged from service and directed him to leave the Assam Rifles complex. Stop. That is how the petitioner was discharged on 1/10/2013. Stop. Agreed with the discharge from service, not as per his choice, but by force. The petitioner is before this court. Stop. Next para. Mr. S. Nath, learned counsel for the petitioner, submits that the petitioner was threatened and beaten up by the commandant and the other officers and JCOs. And for which reason the petitioner had to be hospitalized. For 12 days. Of the petitioner never submitted or agreed to being discharged from service. And that he was forcefully made to give his signature on blank papers. Now, since his discharge from service, has been manipulated by putting him under threat. The discharge of the petitioner from service on 1/10/2013. And the impugned letter dated 11/3/2014, by which his appeal has been rejected, should be set aside and he be reinstated back into service. Stop. In support of his submission, the learned counsel has relied upon the case of Bikram Rana versus Union of India, reported in 2019 to GLT 386. Okay, we'll come back in 5 minutes and continue the education. Oh, he's come.
Forty-seven, the type copy of 48.
Hmm? What thing? Yes, yes. Yes. 47 type copy. So I understand that. My question was something else. Because the one which you gave the record, it's slightly different. That's what I was thinking. B. Sharma, isn't it? You are B. Sharma. Next para, Mr. B. Sharma. Learned CGC, on the other hand, submits that the petitioner is not consistent about the facts leading to his discharge from service. Stop. He submits that while the petitioner contends that it was due to the mistake on his part to enter into his neighbor's quarter that led the authorities to beat him up. Stop. On the other hand, the petitioner in his appeal had stated that due to the prevailing situation in his hometown, he was compelled to bring his family without prior permission from the higher authorities, and which therefore ultimately resulted in his discharge from service. Top. The learned CGC submits that, in fact, otherwise, it was solely on the request made by the petitioner despite being counseled that he will not be getting any pensionary benefit if he opts to be discharged from service, that he insisted to be discharged, which resulted in his discharge from service. Stop. He submits that the application for discharge is duly signed by the petitioner himself, and under the circumstance, the interference of this court is not called for. Stop. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the record produced by the learned CGC. Stop. It is noticed that according to the petitioner, he was manhandled, abused, and beaten up by the commandant of the unit along with other officers, JCOs, and personnel on account of the petitioner having entered in the quarters of his neighbor after midnight on 3/4/2013. Stop. He was called in the office of the commandant the next day, where he was abused and beaten up. So according to the petitioner, he had to be hospitalized for 12 days. And while in hospital, he was forced at gunpoint to give his signature in an already filled up form as well as in some blank papers. To stop, the petitioner was all the time kept under close security, and even though he tried, he was unable to meet the Inspector General bracket South to make his complaint. To stop, it was ultimately on 30/9/2013 that the commandant of the unit called him and told him to meet one Sri Pawan at Guwahati while giving him his phone number, and also informed him that he was discharged from service and he should leave the Assam Rifles complex. Stop, such is the contention of the petitioner in his writ petition. Stop, annexed to the writ petition, amongst others, is the appeal submitted by the petitioner to the Directorate General of Assam Rifles, Shillong, bracket DGAR. I repeat, DGAR. On 18/11/2013. Which is annexed to the writ petition as Annexure 2. Stop. In the said appeal, the petitioner has stated that he was on leave during September and October 2012. And due to the prevailing situations in Garo Hills, he was compelled to bring his family to his unit, that is 30th Battalion Assam Rifles, without prior permission from higher authority. Stop. That due to this reason, he was given heavy punishment by the commandant and one Major S.M. Bhutia. Stop. Because of the punishment, he had to be admitted to the Assam Rifles Nodal Hospital, Mantri Pukri, and was discharged on 16/4/2013. Stop. After being discharged, he was compelled by the state authorities to sign the discharge application, which ultimately led to his discharge from service. Stop. Against the said appeal, the appellate authority found no merit and rejected his appeal. I had said against this appeal, na? Against this appeal. Don't write like that, you write. The appellate, instead of that, you write, the appellate authority did not find merit and rejected the appeal. Against part, you cut that. Up. It is therefore noticed that the stand of the appellant, the stand of the petitioner in his appeal before the DGR and the explanation tendered by him at paragraph number 3 of the writ petition are not consistent. Are not only inconsistent, but contains a different story altogether. So, according to the petitioner, the incident of being beaten up and abused happened on 3/4/2013. Whereas the discharge certificate from the hospital reflects that he was admitted in the hospital on 5/4/2013 and discharged on 6/4/2013. Stop. The diagnosis also, that's what I said, 16/4/2013 discharge. What did I say? Oh, 16, okay. 16/4/2013. Further, the diagnosis which has been shown is generalized body ache. Stop. After the petitioner was discharged on 16/4/2013, according to his own statement, he was set free in the month of May 2013. Wherein, despite all attempts, he could not meet the Inspector General South. Stop. It was finally on 30/9/2013. He was informed that he has been discharged from 1/10/2013. Stop. Although, according to the petitioner, he was kept under close security, but it is highly improbable that he was prevented from approaching his superior authority by writing a complaint or a representation. Between the month of May 2013 till his discharged on 1/10/2013. The respondents in the counter affidavit, more particularly at paragraph number 5, has categorically stated that the petitioner availed leave from 21/5/2013 to 7/6/2013 and from 3/8/2013 to 30/9/2013. It therefore appears that the petitioner had ample opportunity to submit a complaint to the authorities concerned about the incident which happened to him. And in fact, to withdraw his application for voluntary retirement or from discharge from service, which according to him was signed under duress on 16/5/2013. Stop. The petitioner, however, did not make any efforts for recalling the application which was said to be made by him at the behest of the respondent authorities. Stop. The petitioner, in his affidavit in reply, has also not denied the fact of him having taken leave during the aforesaid period. To stop, the records produced by the learned CGC also reveals that the petitioner gave his application for discharge from service at his own request on 16/5/2013, which was countersigned by the commandant of the unit with recommendation. Of the board proceedings, which was held on 17/5/2013, as produced by the learned CGC, also indicates that the board had verified the circumstances as mentioned in the application by the individual and found the same to be genuine. Stop. It was also verified by the board that he was not compelled or threatened for submission of discharge papers, and that the board had personally called the individual and asked about the genuineness of his submission of application. Most of the individual had shown his inability to render further service due to domestic affairs and personal problems, and had submitted an undertaking that no claim for pensionary benefits would be made. Of having noticed what had transpired from the above narrated facts and circumstances, as projected by the petitioner himself, this court has no reason to accept the records which has been produced by the learned CGC. To stop. Next para. Thus, upon due consideration of the case in its entirety, this court does not find any merit in the writ petition, and accordingly the same is dismissed. Having come to the above conclusion, reference to the authority relied upon by the learned counsel for the petitioner is found to be not necessary. Yes, you'll take back the records. Yes. Sorry? Which seniority list? Seniority list of what post? LDA. Under the PWD. There are some private respondents. Anyone representing? You are there. 6. I see. Okay. Then 7 retired. Then who remains? 8. 8 remains. Hmm. So it can be heard.
Most of them were appointed after 1 year, 5 months, 6 months.
Seniority list of LDA. For the purpose of promotion to UDA. Hmm. According to you, you are senior most. Hmm. Illegal.
The committee also thinks that the objection raised by me
Hmm.
were correct. But no action was taken.
Just a minute. Which is the seniority list you're challenging? Thirty-one. This is the seniority list you're challenging. There are only 9 names. So this pertains to a certain division only. Abhayapuri Construction Division. And where is the petitioner? Serial number? Jyoti Rupa. This is the petitioner. Then what about the respondents? Private respondents? Just a minute, huh? Juran Ali. Juran Ali is respondent number 6. Then Kusharam Datta is serial number 3, R7. Then Bipul Chandranath, R8. Hmm. So only 8 remains. This seniority list was prepared on 39/2014. When did you make the challenge? 2015. November.
Because we did 97 plus 40.
22. Page 22 is the provisional. You are at serial number 7 only. Same place. Hmm. Hmm.
How do you load it from working in the department of PWD? What are the names and when they have joined their activity? Page 26 will answer to question number 1. There are 9 bodies in the name of the body. First 4 are the private school. Now, this is the date of joining in the LDA. Now, how many percent are joining the body through promotion in LDA? Now, answer to question number 3. Among the 4 of them is joined as ward information to the names are 7, 6, 8, and 9. Now, in third query, before promotion on what post from when they have joined? Answer to question number 3. Before promotion, when and what post they were in the Utpara also was appointed as officer before promotion and he was appointed on 7/12/2020. Promotion is same 7/12/2020 and he was promoted to the post of LDA on 14/5/2004. Upper part.
Yes.
7/12/2020 and he was promoted on 14/5/2004 to the post of LDA. P1/1994 and you are also to find it was opened on 15/5/2004. Before also was appointed as P1 for before promotion he was appointed on 19/12/2022 and promoted on 15/5/2004. And you are right, was appointed as Chowkidar before promotion he was appointed on 30/12/1996. And the date of promotion is 21/12/2024.
Just a minute. So why are you showing me all this? RTI reply. Hmm. Hmm.
Service.
Hmm. Grade 3 to grade 4 or grade 4 to grade 3? You're talking about demotion otherwise. So they're having only about 2 years and they had been promoted. That's why it's illegal, you're saying. They should have 7 years. What is the provision? Under which provision? Assam? Assam what? Ministerial district?
Classification of the cases of severity comparing from among the grade four staff of the district establishment concerned where fast HSLC or equation and have rendered at least 7 years of continuous service in the district establishment on the grade of the first day of the year in which the selection happened.
7 years. What else? Any educational qualifications there? So all these things happened long time back. Now what can be done? It's 40. What is 40?
Yes. It has been in a sense. This is that.
No one has been promoted means from grade 3 to a higher post. They remain in grade 3. No, what do you want me to show in page 40? Report by? Then what is the conclusion? No, this report was pursuant to which complaint? You submitted complaint. Why this report was called? And this is written to the chief engineer. It refers to your letter number so and so dated 14 November 2014. Where's that 2000 November 14? Is it 37? Application for complaint. Okay, 34 complaint, 35 also complaint, 36 also 36 is RTI, 37 also, 39 also. Then okay, number page 40. So page 40, what is the report ultimately? No, please read what does it say? How is it concluded? What is the conclusion? Page 42. It's a long thing. And page 42 is the conclusion. But it speaks about only out of the 6 vacant posts, 3 numbers were upgraded. Correct? But here there are 4 private respondents. So who was not upgraded? Shouldn't it be 4 instead of 3? So what can be done today? This report is 10 years old only. How do you say that? No, see, you said, just a minute. Where did you record? Oh. Seven retired, 9 expired, 6 transferred. Then 8 is still there. Hmm.
Let them take a call on the proper seniority of the number 8 and
Hmm.
is concerned. We are not selling the initial appointments, so we are already promotions. Only thing of the seniority, you have seen that initial appointments where the promotions were all illegal.
Then what will happen to the seniority list then?
We can yes. These are the elements.
What is the stand of the PWD then? Now, why they are not acting upon this report? You approached this court when? 2015 only. Date is November 18. Report is of March, April, May, June, July, August, September, October, November. For 7 months, they did not act upon it.
Nothing, an inquiry was conducted. Whatever facts I had said in law, were agreed upon, that the authorities came to a conclusion. The activity of the PWD was simply saying that their seniority was prepared on the basis of the date of joining the court.
See, so many things have been mentioned here in this inquiry. Now, in order to take necessary action, I think the affected parties will have to be heard also. Hmm. If parties agree, we can take it.
Our promotion was during year 4, not born on cadre. And subsequently, inquiry report has been submitted here. We were promoted on the basis of the candidates memo number of the year 1990. 2004 is mentioned. May I inquiry?
All right. You see, I think we are out of time right now. If we don't rise, then things will get delayed again. Other things will get delayed. So it's better to rise now. All right, we'll see about that. We'll come back. See, at 2, there's one fixed matter of Aizawl bench. I'll take up that matter first. After that, we'll take up this matter. Okay. You are for the, when do you want it? When do you want it? 1 week. Your Mrs. Okay. On the request of Mrs. A. Bujor Barua, learned counsel for the petitioners. Matter stands adjourned for a week. 16 and 17. Or you're Mr. S. Sharma, isn't it? You're Mr. S. Sharma. We'll adjourn it at your prayer. We'll adjourn it on your prayer. Correct, he's not here, but we'll adjourn it on your prayer. Okay, as prayed for by the parties, matter stands adjourned to be listed again on 20. When do you want it? To be listed again on 24th June 2025. All right.
Therefore, they need to observe that.
Yes. Hmm.
I think of it, protect the area. So, we are only getting by the fact that the submission is invited, but perhaps invited. Because thereafter, after obtaining the order of the honorable court, we went to the site and we did the verification of the order date. So on proof that we received from the ground, was seen that not only allowed 10%, hardly 10% work was initiated matter. Right. So we have taken some photographs of the area under which the project was implemented. And the photograph really shows that they have started the project now. But now the difficulty is now what I have learned from my time today as on day, some progress has been made in the work matter, which in fact my present friend would be in a better position to address this work matter. So what my client today has suggested me, perhaps some discussions he is having with the department pertaining to this work matter. So but in the case of my friend Malala senior, even after maybe some time around, because if the work has progressed, that will be keen not to present the matter. Because ultimately at the end of the day, if they have completed during the pendency of the review petition also, I don't think that the NBCC can again read the tender work and give the remaining part to me or to anybody else. So here the position as on date is making my client a little bit skeptical on whether we should proceed with the review. There is a difficulty. I'm being honest because I also told my senior friend also. So we wanted to just make a request for it.
Time for what?
This is review. Perhaps I could speak from discussing with my client.
No, that decision you'll have to take when this is the right time. Why should we adjourn it like that? Hmm. Hmm. Hmm.
Supposed to complete. Pass the order matter. And if they did not complete matter, then your lordship has the power to review the order matter.
No, that will examine. But your other suggestion that let it be pending for some time, for what purpose? For what purpose? We might as well consider your submissions today and take a call. If I'm not otherwise inconvenient, or if you have some difficulty, you tell me. Otherwise, since parties are here and exactly, he traveled all the way to Aizawl. You were absent last time. But at least you could have informed the court through somebody that you had some problems. Is there anything in your review? Will that be, even if that is to be accepted, will that be a ground for review? How do you say it's an error? Correct. Substantial progress has been made is the recorded finding. Now, no substantial work has been done is your plea based on what? Photographs, how do we accept the photographs like that? This is a writ court, mind you. See, we cannot just say that, oh, from the face of it, it appears like that. From this photograph, it's like that. Can we go like that?
For 22 crores at that particular time, when the order was passed, then I would have. But that is another ground. So if you have to quantify or have to measure certain milestones in achieving that particular project, there is a chart which we need to follow. If at the time when the lordship was security matter, they actually have completed what matter, and they would be able to put in those bills.
Yes, I've understood. So that is your limited ground. That is your limited ground. See, a review is not a case where you open up everything and rehear the matter. You have to immediately show this is the error apparent in the affairs of record, which without much strain, much detailed examination, we can make out there's some error. Then it calls for review. If not, why should we rehear the entire matter?
Pending before the authorities and they have completed, I come to page 27 of my review application. That, ground number 4, I mentioned them. The review petition of obtaining the government verify the progress of the work of the project discovered on 29/2024 that responsible date had not commenced work, respect 8 months that passed in January, April 31, 2024. The total work order value is 3.96 crores. And by this date, after almost 9 months, 32.66 crores, most of work have been completed. Yet no substantial progress has been made. No proof of that progress was made either by NBC, NBC authority, or by employment authority reporting by the new system server. So, this site confirms that project is not starting.
So these photographs was taken on which date? 22/9. No, now today we are in 22/5 of next year, 2025. So you'll not gain anything.
Not the centering of the remaining work.
You have the apprehension that they'll retender the work. You have the apprehension that they will retender the work. You are hoping that some retendering will be done. Is it like that? Yes, yes. There'll be no question of retendering. If work is on now, then you make a submission, we'll take a call. Why should we adjourn the matter like that? For what? The work will keep on progressing like that. And ultimately, you want the matter to become infructuous, or what? We'll take a decision today. No, if you have some genuine problems, apart from what you're just indicating, we can accommodate. But if it's just to see what happens in the near future, let us wait and see. That will not, that we cannot permit. So there and then you should have struck when the iron was hot. After 1 year, you cannot say that work did not start that time, so now we go back to that time.
I think, yeah, that's likely admitted. We should find your friend. Hopefully, come by this. Whatever the time, there is a I have done this, I have drawn the figure, not good. What will you say, 114 and 47, there must be an error as far as on the decimal. My bandage will be a error within the error. What is this substantial? That is a big deal. So, section 114 and order 47(1). Order suffers from error as far as on the face of the record, permitting the same to lead to failure of practice.
Order 47, Rule 1, is it? Section 114, CPC. You had also mentioned something about the delay last time. 30, section 30 days. Article 164 or 124, something like that. 124. But there's one judgment relied upon by Mr. Burgoyne that the CPC does not apply. But at the same time, the duty is cast upon the person to satisfy the court that he was prevented from coming. No, there's a pleading. Some pleading was pointed out specifically.
So wrongful statement should not be made. Normally,
Paragraph 6. Mr. Burgoyne, paragraph 6. Review petitioner submits the review petition has been filed within period of limitation. So you also agree that there is a period of limitation? Accepted. For the sake of argument, accepted. But why do you admit that there is a period of limitation then? In your paragraph 6? If there is no time prescribed, that means there's no time prescribed, there's no delay. You can file any time. 5 years, 10 years, 20 years, no problem. But your statement, you admitted, review petition has been filed within the period of limitation, which indirectly means that you also accept that there is a period of limitation. So what is that period? Spirit.
Any order decree from the court below. But there is a requirement to file an application to confirm delay, but High Court is going to contemplate that limitation because my first I have taken in mind application is that my introduction is on page number 1. It is filed under chapter 10 of the High Court rules, where with section 114, 414 and 151 of the
114 also is there. CPC.
And is silent on limitation. People ultimately kindly come to High Court rules.
Mr. Burgoyne, I don't think we need to discuss so much. We'll take a call. All right. I've understood your case. Okay. I'm dictating. Please relax, have a seat. Heard Mr. H. Burgoyne, learned counsel for the petitioner, and Mr. A. Thakur, learned senior counsel, assisted by Ms. J. R. Thakur, learned counsel for the respondent numbers 1 to 6. Stop. By filing the instant review petition under chapter Roman 10 of the Guwahati High Court rules, read with section 114 and section 151 of the Code of Civil Procedure 1908 bracket CPC, the petitioner prays for review of the common judgment and order dated 22/8/2024, passed in WPC number 76 and 77 of 2024. So brief facts, next para, brief facts of the writ petition has been set out in paragraph number 2 and 3 of the judgment and order dated 22/8/2024. And therefore, for the sake of brevity and convenience, the same is being abstracted here under. Paragraph 2 and 3, okay? page 35 and page 36, A to A. Next para, Mr. H. Buragohain, Learned Counsel. By referring to the grounds of review in the instant review petition, submits that this court had restrained itself from interfering with the tender process. On the ground that the work oblique project involved had substantially progressed and 8 months had passed So therefore, since the project was in the midst of execution, which also involved national security and public interest, desisted itself from interfering with the tender process and thus dismissed the writ petitions. To stop, the Learned Counsel submits that however, it has come to the knowledge of the review petitioners as recent as on 22/9/2024 that the contractor concerned had not even started to execute the work in question, despite the fact that 8 months had passed from the date of issuance of the letter of award. Stop. The review petitioner, in order to fortify the said statements, have relied upon a few photographs which was taken on the project site and which are annexed to the review petition. The Learned Counsel therefore submits that because of such error, the impugned judgment and order should be recalled. To stop, he otherwise submits that if the opposite party is able to show that work had substantially progressed as on the date of the judgment and order of this court in the writ petitions, the review petitioners cannot have any say in the matter. Stop. However, he submits that it is clear that as no work had started, the finding and observation of this court that the work had progressed. Being an erroneous finding, the impugned judgment, the judgment and order passed in the writ petitions should be recalled. Next para. Mr. A. Thakur, learned senior counsel. No, before that you write like this, cancel that. Mr. H. Buragoain also submits that since the review petition has been filed under Chapter Roman 10 of the Guwahati High Court rules, which does not prescribe any period of limitation for filing a review, it cannot be said that there is delay in filing the review petition. And that there is no bar in entertaining the instant review petition. Next para. Mr. A. Thakur, learned senior counsel, on the other hand, submits that the review petition is also filed by invoking section 114 of the CPC. Stop. In order to file a review petition under the said section, the period of 30 days has been prescribed by Article 134 of the by Article 124 of the Limitation Act, 1963, open bracket Limitation Act. So therefore, it is clear that the review petition having been filed on 19/2/2025 and the order sought to be reviewed having been passed on 22/8/2024, the review petition has been filed beyond the period of 30 days prescribed. And on this ground itself, the review petition should be dismissed. Stop. The learned counsel, the learned senior counsel has also the learned counsel also submits that the review petitioner has made a wrong statement at paragraph number 6 of the review petition, wherein it is stated that the review petition is filed within the period of limitation. Stop. The learned senior counsel submits that otherwise, any explanation? Any explanation about delay? No. Learned senior counsel submits that even if it is to be accepted that the review petition is not circumscribed by 30 days, as per the Limitation Act, the review petitioner has failed to make any explanation in the review petition, and for which reason the review petition is liable to be dismissed. Stop. This one. In support of his submission. State of Tripura, this one. Learned Senior Counsel, in support of his submission, has relied upon the case of State of Tripura and others versus Subbal Kumar De, reported in 2011, 1 GLT 290. And the case of Umesh Chandra Lakar versus Siba Ram Deka and others, reported in 1990, 1 GLJ 518. You have annexed it? You have a copy? Give me. One or two, how many? Delay, on delay.
Fundamentally based on our code of and it can be another.
Would you like to quote the paragraphs? Tick mark. Okay, anyway, we'll consider. Next paragraph, the learned senior counsel further submits that no statement or evidence can be found in the review petition which can be considered to constitute discovery of new and important evidence or matter which after exercising due diligence was not in the knowledge of the person seeking review. Stop. The petitioner has only made a veiled attempt to raise a dispute about the quantum of progress in executing the concerned contract work, which otherwise is a complete separate issue and not connected to the issue raised by the review petitioner in the writ petition. Stop that. The same in no manner constitutes discovery of new and important evidence or matter, which after exercising due diligence was not in the knowledge of the person seeking review, as the review petitioner was all along working in the area adjacent to the site where the concerned contract work for flood lighting was to be carried out, but engaged in a different work that is border fencing, etc. The learned senior counsel submits that a review petition is by no means an appeal in the guise, an appeal in disguise, whereby an erroneous decision is reheard and corrected. To stop the same not being discernible in the present review petition, the review petition should be dismissed. To stop, he also submits that it is for the principal client who had assigned the contract to inspect and verify the progress of the contract work concerned through appropriate means and to take necessary steps in terms of the contract agreement, if so required. To stop, it is by no means in the domain of the review petitioner to get the progress of the contract work measured and verified by their own staff members in an illegal and unauthorized manner. To stop, the learned senior counsel thus submits that the review petition is not maintainable, both on delay and even on merits, and the same should be dismissed. Beginning part I have submitted, na, Mr. Borogohain. You add this line, okay? Mr. Borogohain, H. Borogohain, learned counsel for the review petitioner in support of his submissions, has relied upon the case of Perry Kansagra versus Smriti Madan Kansagra, reported in 2019, 20 SCC 753, and the government of NCT of Delhi, through its secretary, Land and Building Department and another, versus KL Rathi Steels Limited and others, reported in 2024, 7 SCC 315. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. From the grounds set forth. No. Before adverting to the merits of the review petition, since the question of delay has been raised by the learned senior counsel for the respondents, it may be apt to refer to section 114 of the CPC. I've given you two judgments just now, isn't it? Perry Kansangra and government of NCT. Two. We add one more. Board of Control for Cricket in India and another versus Netaji Cricket Club and others, reported in 2005 for SCC 741. Do we have the Limitation Act somewhere? The last sentence, ka? Right, no, just instead of that 114, you write Article 124. Of the Limitation Act. Now, as per Article 124, it is provided that the period of limitation for filing a review of judgment by a court other than the Supreme Court is 30 days. And the period from which time begins to run is from the date of decree or order. The BCCI is also regarding limitation. No, anything on limitation? This is not on limitation. I'm asking about limitation. Oh, that is on review. What is this? This is by the Maharashtra. Yes, this was somewhere available in this review petition also, isn't it? I had seen it somewhere. I had seen it somewhere. I'm trying to locate it. So anyway, you gave me. Hmm. Was it the same judgment? I remember there's another judgment somewhere. Mhm. Is it the same judgment? Hmm. So in this connection, it may be gainful to refer to the judgment rendered by a division bench of the Bombay High Court on 8/2/2021 in civil appeal, in civil application bracket CAO number 21 of 2021. In Miss Civil Application number 5757 of 2020, arising out of WPC number 7009/2019, bracket capital D, open bracket, Lakshmikant Sambhaji Khade versus the state of Maharashtra, close bracket. Red flag, okay. You'll get the details in the red flag. Pink flag, sorry. Wherein the applicability of Article 124 of the Limitation Act applies to the judgment delivered by the High Court in exercise of the powers under Article 226 of the Constitution of India was considered. To stop the Bombay High Court, in the given facts and circumstances of that case, held that Article 124 of the Limitation Act would not apply to an application for review of an order or the judgment passed in exercise of powers under Article 226 of the Constitution of India. Stop. However, it was clarified that the High Court may not ordinarily entertain an application for review if such application is made after the lapse of a period of 30 days on the ground of public policy not to entertain such application beyond the period of 30 days after passing of the order. Stop. It would, however, be open to the High Court to entertain in a given case the application for review, even if such application is filed beyond the period of 30 days, provided the High Court is satisfied that the applicant had sufficient cause for not being able to apply for review earlier. Stop. The delay in filing an application for review can be explained in an application for the review itself, and separate application may not be necessary. So by applying the said principle in the present case, it may be seen that the applicant, the review petitioner, ought to have made some explanation as to why the review petition was not filed within a period of 30 days. Since it was admittedly filed beyond a period of 30 days. To stop. In fact, the petitioner at paragraph number 6 of the review petition has categorically stated that the review petition has been filed within the period of limitation. Stop. The same would therefore go to show that even according to the petitioner, there is a prescribed period of limitation for filing a review petition. Stop. Under the said background, and without there being any explanation as to why the review petition could not be filed within a period of 30 days, this court would have no option but to draw an inference that the review petition has been filed beyond the period of limitation and therefore should be dismissed. Stop. However, notwithstanding the said observation and finding, this court is not inclined to dispose of the review petition solely on the ground of delay. Stop. The review petitioner has taken the ground that despite the fact that no work had progressed, at the time of passing of the judgment and order in the writ petitions, court had declined to interfere with the tender process by dismissing the writ petitions on the premise that work had progressed and it was in the midst of execution, which also involved national security and public interest. Stop. In order to substantiate the ground taken in the review petition in this regard, the petitioner has stated that it has come to their knowledge as recently as on 22/9/2024 that work has not progressed despite the issuance of letter of award 8 months earlier. To stop the ground situation prevailing at the place of execution has been sought to be projected by enclosing few photographs of the project site. Where work in question is to be executed. Of an area covering 0 kilometers to 5 kilometers in the project site. Stop. According to the review petitioner, since work had not started, and the writ petitions having been disposed of on the premise that, not disposed of, has been rejected on the premise that work had already started, amounts to a ground for seeking review of the judgment and order. While such is the stand taken that work had not started and which information came to the knowledge of the petitioners as recently as on 22/9/2024, it may be seen that much time has passed since 22/9/2024, and that it is admitted at the bar that work has since progressed. Stop. The only dispute that is being made as on today is as to whether the contractor had completed the amount or volume of work which was due to be executed as per the contract agreement. Of the fact remains that this court, taking into account the projection made by the parties concerned in the writ petition, had taken a call that in view of the work order, letter of acceptance having already been issued and the work apparently have been initiated to some extent, declined to interfere with the tender process. Such a finding in the considered view of this court cannot be countered by producing of photographs taken at the work site to show that work had not started. Up. One cannot lose sight of the fact that the instant proceeding has resulted from the writ proceedings and can only be understood as a continuation of the said proceeding. Now, it may further be noted that in fact, it was not even the case of the review petitioners in the writ petition that the work allotted had not started. Stop. This court, in the case of Umesh Chandra Lakar, in the given facts and circumstances of that case, held that a party not entitled to seek review, a party is not entitled to seek review of a judgment delivered by the court merely for the purpose of rehearing and a fresh decision of the case. Particularly on points not urged earlier in the petition at the time of hearing. Of the scope of review, as explained in section 114 of CPC, is that a review can be invoked if the order suffers from error apparent on the face of the record, leading to the failure of justice, or discovery of new important matter or evidence, which despite exercise of due diligence was not within the knowledge of the applicant or could not be produced at the time when the order was made. Or the order has been passed on account of some mistake and for any other sufficient reason. Stop. In the present case, as stated earlier, the grounds set forth mainly for preferring the review petition is that the work which was thought to be executed had actually not been executed by the contractor concerned. Such an averment, as already stated, without being substantiated by admissible evidence, cannot be accepted in a proceeding such as the instant review petition. What is this case, Perry? You have relied upon any paragraph? No, Perry Consagra. 19. Which paragraph? This is basically what is the provision of 114 being reiterated, that's all. All right. So. Which case? Yes, yes. No, where have you submitted that? No, but it's not here, na? All right, we'll see. If necessary, I'll incorporate it. But I'm dismissing this review. Thus, upon due consideration, if this court finds no ground to review the judgment and order, And accordingly, the review petition stands dismissed. Yes. Mm. Mm. Huh? Seven. When? Okay, as paid for by the parties, list the matter again after 2 weeks. Right. Learned State Council, Learned State Council to produce the records on the next date. All right. Item number 13. Petitioner, how much? All right. We were dealing with which item? 6. Page 40. Hmm. Hmm.
Not just rural development, right? This of as sitting item, he was engaged in the duties of an office clerk. So he was initially working as a workshop employee. Handyman. Since he was sitting island, he was engaged in the field. Right? Rural details, like, he submitted careful upgradation of his service. With the post of LD assistant, which was already the service selection. See, people follow Dr. Evans' solution was the person activity.
Okay, tell me one thing. If action is to be taken as per this report, then what will happen to the others? Those who have expired, those who have been transferred?
The others have been, one is retired, the other is expired, and one has been transferred to some other division. We will be doing out from that. For the date of joining in that particular. So. But you know, government has either reply. Yes, there is a paragraph. Anything, the epidemic of the. 1, 2, 3, and 4 and 5. Paragraph 9.
Respondent number? 1, 2, 3, 4, and 5.
But still.
Just a minute, where is that? Yes, 1, 2, 3, 4, and 5. Paragraph number? 9 and 10. Yes.
Was prepared on the difference of the date of joining the court of LDS system as per recorded in the subject book and we publish this with the latest solution. Now, versus so far the anomaly is concerned, which we can come to paragraph 10. That is equal to the paragraph 8, 10, 12 to 14 of the deponent, that is the right stated there. And while regards to paragraph 11, the deponent offers no proof. Paragraph 11 refers to the anomalies. Now, paragraph 14, next page. As regards paragraph 18, 20, 23, 24, the deponent definitely stated there. Paragraph 16, how he was promoted. That is because paragraph 12 of the implication, the deponent accepted the promotion to the court of LD in favor of the Uparan of the Roman Maliba and was made as part the undertaking to the letter translated election. So, I think means a surprise of the authority. Because that not identified a reply.
Which paragraph you were referring to just now?
There are also indications 14 to 16 of the affidavit filed by the PW.
14 is admission. 15 is no comments.
16
10 also.
guidelines by which the person. There are certain things which are required in case of master or minimum 15 years have to be there for the application to the post of to a grade 4. This respondent number 8 was a work chairs employee. For application of minimum 15 years service is required. Since he was sitting idle, he was temporarily posted as a cure. Thereafter, within a period of 1 year, he is promoted to the next higher post.
Can you show me that 7 years thing? In this book. Assam 91191. Okay. Rule 7, is it? Or Rule 5?
6 by B.
6(5)(b).
Okay, then we got look here, and after we got by selection, it's by selection on the basis of relative content.
Just a minute. 6 is junior assistant. By direct recruitment. By selection on the basis of.
High school living certificate or equivalent expenses. And have rendered at least 7 years of continuous service in the district expenses on the first day of the year in which the state is.
This is a case of district. Which place? Abhaypuri. So how was the promotion made?
Letter of the undersecretary. Page 16, paragraph 16 of the affidavit of the signed by the PWD department.
Paragraph 16.
As regards to paragraph 20 of the petition, the deponent Lexus states that the promotion to the post of LV assistant in favor of Sri Shri was made as per undersecretary to the government letter dated so and so. Tenth of May 20. But I'll just refer to notification.
As per letter, what is this letter? It's not enclosed also. What does it mean? What is this?
Notification.
Hmm?
I'm glad to say there is a second page. That there is a specific provision under rule 6(5)(b) of 6(b) of the Assam Ministerial Living Regulations for promotion of grade 4 employees having requisite qualification to a reserved quota of 10% of vacancies in the cadre of LD assistants in the amalgamated establishment of the deputy commissioner of the district.
It's 10% or 15? When? Rules is of 1967, is it? And this circular or this information is of 1973. 92. In the year 1992. That is why. I had come across that 15, that's why I'm asking you.
That same policy is respect of promotion of qualified grade 4 employees of at least 10% of the cadre of LD assistants in the district of subdivision established to district followed by all district and subdivision of law. This was of 26th of September 73. Now also it now come to the first page. This is regarding inclusion of proposal for upgradation of promotion of service of emergency. If it is referred number D for the Roger Elwell. Inviting reference some style above. I'm writing there is no specifically going to provide promotion upgradation of service of MR laborers delivered to the higher post, and the services of MR laborers are regular as grade 4 employees. Only after completion of 15 years continuous service in the department with the concurrence of the finance department. The upgradation promotion of the services of the MR laborers to any higher post will be a new appointment for which the service should be follow strictly. And the vacancy should be advertised after getting approval of the SLEC. There is no bar for qualified MR laborers to apply for the same this case may be considered as per. In view of your requested can not initiate any proposal for upgradation promotion to the service of MR to any higher post of the government for consideration and this announcement the necessary direction will be issued to also. The Roshi will see 15 years is required. Now, if you go by the so far the other respondent will not, I am not concerned now.
Why are you producing this document separately?
Years requirement is there. What has happened in the case of RA?
7 years or 15 years? No, as per the rules, it says 7 years.
Grade 4 to below. 4 to grade 3.
What do you mean by 15 years?
Four, it is public by, it's showing, was filed on 1/10/1993. Yes, versus roller handling. Why? Office order dated 29/9/1993. So his date of birth is 1993 as a virtual employee. As he was sitting idle, he was engaged in the use of the office space by letter dated so and so 2002. So the 15 years criteria is what here?
No, that's what I'm asking you, that 15 years criteria is for what? Grade 4. In order to be upgraded, you need 15 years. And from that grade 4, 7 years to grade 3. Matriculate. So what can be done at this stage now? Mr. Das, you are for respondent number 8. Hmm.
Correct. Data number transfer, data, presently received from the undersecretary in government of some office reply to data emergency. See, Yendor Roy, whose name was enlisted in serial number 5 of the serial is published on the Malabar 24/9/14 was passed in service 96 as either on professional grounds. I two numbers answer 96. He submitted prayer for upgradation of his service to report of the LDA, which was forwarded to the Chief Engineer Assam Sanmani on Mother 5/12/2003. The services of so on the assistant was and memo number so of the heavy sediment and qualification HLC SSLC 92. Next page, madam. In the matter of education or qualification, an amendment was made in the year 1988. Under the secretary to the government of Assam Personnel Department on 25/6/92, and as per the said amendment, the minimum requirement of educational qualifications should be SSLC pass for the LDA Assam ministerial staff. The quota of promotion of grade 4 post of law division assistant is to be 50% as per the letter issued from the above under secretary to government of Assam in the 25 May 1992. In this section, it is mentioned here that as per PO letter number dated 18/6/2003, there was 6 numbers of LDA posts lying vacantly. 18/6/2003, it was a vacant post of 2003, and out of these same 6 vacant posts, 3 numbers of were upgraded from grade 4 to the post of LDA on letter 4/5/2004 and 5/2004. So they were promoted, they were upgraded in the year 2004 itself. Now kindly tell you the list of the seniority list, my lord. Final list, my lord. My lord, 29, my lord.
31. 29 is provisional, I think.
Yes, sir. And such part of I order the 24/9/14, the security is from the LDA system under available which have been prepared. Here response number 4 is response number 8. Then serial number 4, he was joining the division 2002. As it is seen, joining the grade 4 post in the year 7 with 1912-17. Here, remarks from this mention, orders for promotion of the incumbents at serial number 2, 3, grade 4 employee to LDA were signed by the executive engineer on the same grade 14/5/2004. But the promotion of the investment of the incumbent serial number was issued on 15/5/2004. The incumbent Suranali serial number 2 was exposed to the LDA at serial number 4, 3 as get for employee in the division. There fixed manner in the next page also final list. This manner page 29. The restaurant number eight name is FCL number four. From there, madam, 2015, 2004, joined as LBA and the petitioner here, that serial number seven, she joined on 1/5/2008. That is after 4 years of my promotion. She was appointed directly in the post of LBA. So according to me, my lord, this apprentice, he was not in the cadre, my lord, earlier, my lord, and she cannot challenge the seniority position, my lord, now after my lord, long back, my lord, after 7, 8 years, my lord. And that's why, my lord, your lordship has already settled the past in judgment, my lord. And since we are, my lord, they specifically mentioned.
No, see,
Members of the same grade has to be counted from the date of initial day entry in the grade. Judgment was passed by your lordship. It's a reported case, matter. Online. Then specifically paragraph 15 and 16. The lordship of that we are matter. That one already settled position cannot be set after long break, matter.
no, this seniority list. No, this impugned seniority list is of which year? When writ petition was filed? So how do you say that is long settled?
Submitting the matter on the basis of the list of the 2004 promotion. 2004 promotion of the respondents. It is the case.
Correct, but that seniority list has been finalized as per page 31, that is 39, 2014. So
They were promoted in the year, my lord, 2004 itself. And she has been got appointed, my lord, in the year, my lord, 2008. So she come after 4 years on. Thereafter, my lord, as her name is not, my lord, from the merit come seniority, but it is from the seniority come merit, my lord. So our petitioner position is at serial number 7, my lord.
but you tell me, are you qualified to be appointed or promoted? No. Not the educational qualification. I was referring to the number of years. Because the district rules says 7 years. The district rules says 7 years. You have completed just 2 years.
Was given that, 2004, private restaurant were promoted. She is mentioning this figure, madam. So far, madam, from LDA to EBA, that is, she is behind us, my lord, because she has been appointed in the year 2008. But appointed in, promoted in the year 2004. So there is a 4 years back, my lord. So far, 2004 list is concerned and promotion is concerned, she cannot claim. So there was no challenge at the relevant point of time. And she was also not born into the killer. Now, at this moment, she cannot, my lord. Every step she has mentioned here, my lord, that the promotion 7 years, whatever may be, but at the relevant point of time, specifically mentioned in the annual report, it is on the basis of the memorandum of the year 1992, they were promoted. But she cannot say, my lord, that it has not been followed.
No, the seniority list, when was it settled? No, that was promoted. I'm talking about seniority. Seniority settled in 2014. Writ petition filed in 2015. How do you say that this is all belated challenge? Obviously, it has to be based on something. Seniority list cannot be just made in the thin air. It has to be based on your entry into the service or your promotion like that. But until unless a final seniority is published, nothing is final. Publication came in 2014. And it's not that they are challenging this 2014 today. They filed the writ petition in 2015.
That is why, madam.
Is it like that? You're challenging the promotion of 2004.
That's why she has not got appointed, madam, promoted. Because our names are there in the property list, because we are senior to her, madam.
So it is your promotion is not based on the basis of your entry into the service. It is on the basis of your seniority. Seniority reflects your entry, whatever it may be. But the basis is your seniority. So why not seniority cannot be rectified at this stage? Where is the impediment? Then settled matter. What is settled? Your appointment, not seniority. Seniority, no. No, seniority was settled for how many years? Final came only in 2014. Not LDA, isn't it? UDA.
But so there is no restriction for us. We are senior to her, that's why we are promoted.
No, that is why he has challenged the seniority list. Seniority list has been wrongly made. That's why he's challenging.
Initial appointment or promotion of the initial early stage.
Ah.
Entire case is based on upon that. That's why, madam. After 2004, what she can say, madam? Madam, they cannot claim. They cannot claim that she is senior to us. How can it be, madam? She was directly recruited in the appointed in the year 2008 itself. And we are appointed in the year 2004. From the appointment itself, initial appointment or promotion, first promotion, whether she has any case, that we are not eligible for their promotion. We are eligible on the basis of our promotion given at the relevant point of time as per the earlier. That's why it is specifically mentioned.
As per the report, you have been promoted after 2 years. Rule says 7 years.
That is, madam, that 2004 promotion.
Exactly.
But since she cannot challenge.
Why not?
Yes.
No. See, your seniority of 2014 has direct nexus to your initial appointment. Correct. Now, petitioner says that when you were promoted, even without completing the minimum years of 7 years,
Was made as per the undersecretary to the government of Assam, draft letter dated 10 May 2004. Yes, 5, in the ability of original filed by the reference number 154 and 5. Next is the promotion report of NDA and Intermediate those of Iran Army basis of was made as per undersecretary to the government of Assam, PWD branch letter. Reference number 10 May 2004. Paragraph also it is mentioned. Paragraph 70. The deponent says that the promotion of the from the person when as per the under the government of Assam there will be there was no alternative way for correction of the community. So there was no complaint on this from any owner at the relevant point of time. That's why they were giving promotion in the year 2007. The latecomers with the regular stream cannot see a marks over the early arrivals in the regular queue. Since the urban matter. Then get asked. I thought also, doesn't really affect the administrator. And we know what's it done, and for parking. For my. On the thing that I want to. Paragraph 14 and 15 matter. Determination criteria for service on probation or in officiation capacity whether to be counted for determination of seniority and in case of probation of officiating appointments which are followed by a confirmation unless a contrary rule is shown. The service rendered as officiating appointment or on probation cannot be ignored for recording the length of the continuous officiating service for determination of seniority. When the initial appointment is not in accordance with prescribed procedure of work, such appointment is approved subsequently, the approval would mean is confirmation and the same would relate back to the dates on which the initial appointment was made. This one say again, the ancillary service will be completed in following the security according to the length of continuous service. It was reported in 2001, entire period are concluded. That's why in each of this one, it specifically mentioned merit come, seniority come merit. After seniority has to come, thereafter merit.
Yes, Mr. There.
Promoted to
Hmm. Yes. Hmm.
by that time. They on which I was about. This seniority is was finalized. That's written finally. That is what is writing. That is why I cannot challenge.
Which seniority list?
That is, in fact, there is no seniority list. What is he saying? The seniority is already been determined. That is, there is no seniority. But the seniority has already been determined and it is finalized. And I cannot challenge. Now, what you will see.
Is there any other seniority list before this 39/20/2014?
That is why page 22 is the provisional seniority list, which was published for the first time after I was on. This is the provisional seniority list.
Yes.
I raised my objection immediately within 10 days.
What was your objection? No, what was your objection?
Doctor, his appointment.
Their appointment.
Which one the doctor? The doctor kindly come with reference to the subject matter above, I asked the owner to inform that the provisional seniority is published by the Judicial Office, but a lot of anomalies regarding this provisional seniority have been found. As per office record, it has come to my notice. The serial number 4, it was specific. Incumbent was a work choice holder handicapped before he joining as a healthy assistant. I therefore request owner to go through the proper check and document and then to make a genuine seniority as per the early assistant and Tazo. So it was his appointment which was under challenge.
No, he may have been a work charge roller handyman. So what is wrong in that?
That case, that again, he appointed as a grade 4, he updated as a grade 4. 15 year service is required. That was not there. Then, from grade 4 to grade 3, 7 year service is required. That was also not there. That is why, my lord. Yeah, that is not. No, I'm not. This is, I'm not saying it from my own, my lord. These are office memorandums. And what my lord has referred to, in the affidavit, this is a letter of promotion.
See, seniority is of 2014, the provisional. Then to challenge that, you're going back in time in 2004. Correct?
Prior to 2014, there was no seniority list.
No, there's no seniority, correct. No seniority list. But once the seniority list came provisional, then you say that how come these people are above me? Because their source of appointment is from some other as master role. Hmm.
I raise an objection. Thereafter, the provisional list was placed, Thereafter, since it was not considered, I find out the representation, and then inquiry was made. And the inquiry, it was found that the allegations which I have raised are correct. But they did not act upon it. And superior thus I have come to this court.
Hmm.
Still below is a long process when they will 3 about them gone. Only thing the respondent number 8 has remained in the
15, you came in 2015 and now we are in 2025.
Because of this case, none of the promoted, either he or me. No, it's.
Promoted as UD.
When it's of this case, no one has been promoted. In fact, that is my problem, they wanted transparent level. One expired, one retired.
Was there a stay order or something? Why?
In the affidavit, but they admit the anomaly. The department admits the anomaly.
Any interim order passed? Are you sure? So for 15 years, everything is standstill. I mean, sorry, for 10 years, things are standstill.
The initial appointment. And what my learned friend has referred to, you also that page, paragraph 16, my learned friend just referred.
See, under the circumstance, I think, see, if there's a report to that effect, let the authority take a call. Mr. Das, let the authority take a call and let them also give the opportunity to the respondent, your respondent number 6, respondent number 8, before taking any decision. Because this court cannot straight away say this is right. Do it. That will be detriment to everyone.
So ultimately, what I have stated is from the.
See, whatever is there in the inquiry, let them consider, take that into consider and take a call within a specified time and by giving due opportunity to the parties to be who are to be affected. So whatever is the outcome, that will be different. It will be a separate issue. He may not also get anything, but at least things will move forward, isn't it? Somebody will go up who's eligible will go up. All right, whatever it has been said, let them appreciate it and let them take a consideration. All right, please write down, heard Mr. R. De, learned counsel for the petitioner. Then Mr. H. Das, learned counsel for respondent number 8. Who else is there? And Mr. H. Das for respondent number 7 and 8. Then Mr. M.U. Mondal, learned counsel for respondent number 6. Just a minute. You are for 6 and 9. No, 9 expired. There's some different thing that will come to later on. Then Mr. H. Das is for 8. 7 and 8. 8 retired. 8 retired. I mean 7 retired. Then who else is left? 7, 8, 6, 7, 8, 9. Then for the department, who appears? None appears for the PWD respondents. Stop. The petitioner, by filing this writ petition, has challenged the final inter-se seniority list of LD assistant under Abhayapuri Construction Division, Abhayapuri, issued by office order dated office order number 51, dated 30/9/2014, bracket annexure J. Stop. According to the petitioner, prior to issuance of the final seniority list, a provisional seniority list was issued on 9/7/2014, bracket annexure C, wherein the petitioner's name appears at serial number 7. Stop. The petitioner submitted his complaint before the respondent authority concerned with regard to his placement in the seniority list. But however, when the final seniority list was published, his position remained the same at serial number 7. Stop. Aggrieved, he is before this court. Next para, Mr. R. De, learned counsel for the petitioner, submits that the petitioner has come to learn that the private respondent numbers 6, 7, 8, and 9, who are placed above him in the seniority list, above her in the seniority list, in fact, were earlier serving on muster roll basis. And without completing the required length of service of 15 years, they have been inducted into grade 4 post and thereafter promoted to the LDA post. Stop. He submits that in fact, the respondent number 8, whose name appears at serial number 4 of the seniority list, was a work charge roller handyman before his joining as LD assistant. Stop. Since there is anomaly, correct. But that absorption was with even before completing 15 years. What is the last line? In his absorption to a grade 4 post before completion of 15 years as work charge, he could not have been placed above the petitioner in the seniority list. To stop, the respondent authority is considering the grievances projected on the impugned seniority list had directed the executive engineer, PWD bracket NH, Abhayapuri Construction Division, to submit a detailed report to stop the said authority thereafter via communication dated 10/4/2015 bracket annexure R submitted the report to the chief engineer, PWD bracket NH Works, Assam, Chanmari, clearly indicating the various anomalies and irregularities in the manner in which the parties concerned have been promoted oblique appointed to the post of LD assistant. To stop, despite the said report, since no action has been taken, the petitioner, having no alternative, has filed the instant writ petition. To stop, Mr. R. De, learned counsel, referring to the counter affidavit filed by the Department of Public Works, has submitted that the averments on irregularities in the appointment of the private respondents to the grade 4 post and thereafter to the grade 3 post has been clearly highlighted against paragraph number 10 and 14 of the writ petition, amongst others. No, in your writ petition where? In 10-14, you cancel that. In paragraph number, give me 2 paragraphs. I think you are referring to 10, 14, 15, and 16, isn't it? Counter. Please repeat the sentence. What did I say? Just read. Okay, paragraph number 8 to 10, 12 to 14. No, 12 to no. You can write from paragraph number 8 to 10, then 12 to 27, 12 to 28 in the writ petition. And that in the counter affidavit, the respondent authorities have not only offered no comments, but in fact has accepted the fact that there are anomalies. Stop. He therefore submits that, such being the position, the respondent authorities may be directed to consider the case of the petitioner, maybe to consider redrawing the seniority list and placing the petitioner at the appropriate place. Stop. Next para, Mr. M.U. Mahmood, learned counsel, submits that I'm sorry. Mr. M.U. Mondal, Learned Counsel, submits that respondent number 6 has already been transferred to another division. While the respondent number 9 has expired. Stop. He submits that even if the seniority list is to be redrawn, the respondent he represents cannot be affected. Next para, Mr. H. Das, Learned Counsel for respondent numbers 7 and 8, submits that respondent number 7 has since retired from service. And as for respondent number 8, he still remains as an LD assistant.
As per the works as master handyman, and subsequently he was adjusted on 1912 on master and service road, or a service book, service road and gross office bill and model 1912. So both the posts are there close.
From where you're saying that? From where are you saying that? Which paragraph? Anyway, that they will consider, okay? Okay. And as for respondent number 8, he still remains as an LD assistant under the establishment of Executive Engineer, Public Works Department, Abhayapuri Construction Division. Stop. The Learned Counsel submits that the petitioner cannot be allowed to challenge the seniority list in view of the fact that he was only appointed. She was only appointed as LD assistant on 1/3/2008. Whereas the respondent number 8 had already been appointed 15/5/2004. So therefore, the petitioner cannot claim seniority before she is born in the cadre. So in support of his submission, the Learned Counsel has referred to the case of Veduzo Sasu and others versus State of Nagaland and others, reported in 2023 to GLR 965. And also the case of L. Chandra Kishore Singh and others versus State of Manipur and others, reported in 2000, Volume 1, GLT SC 32. Next para. It may be seen that the challenge made by the petitioner in the instant case is with regard to the final seniority list dated 30/9/2014, wherein she has been placed at serial number 7 of the list. No, you cancel that again. It may be seen, no, I'll say that. It may be, next para, it may be seen that prior to issuance of the final seniority list dated 30/9/2014, a provisional seniority list was published on 9/7/2014, wherein the petitioner's name was placed at serial number 7. Stop aggrieved with the same, the petitioner submitted representations as well as sought for certain information through RTI application. To stop following the same, the chief engineer PWD NH Works had instructed the chief engineer had directed, is it? Page 37. 37 is the typed copy.
Page 36. This was meant to be the speed at table.
Seeking a detailed report. Then what about 37? Okay, so last line. Just read again. Little ahead. CE, they make it SE. You write like this. Following the same, the superintending engineer PWD Nalbari NH Circle had written to the executive engineer PWD Abhayapuri Construction Division to take appropriate action in the representation submitted by the petitioner. So likewise, the chief engineer PWD NH Works had also directed the executive engineer concerned to submit a detailed report on the matter. So accordingly, the executive engineer, via his letter dated 10/4/2015, had submitted a detailed report with regard to the manner in which the seniority has been drawn in respect of the LD assistant concerned. To stop, the executive engineer has also indicated No, cancel that. The executive engineer has the cancel now. Stop. However, no further action appears to have been taken by the respondent authorities concerned in the matter. And it is stated at the bar that no promotion has been made to the post of UD assistant by relying upon the impugned seniority list till date. Now, as already noted, respondent number 7 has since retired from service, while respondent number 9 has expired. And respondent number 6 transferred to a different division. Stop. Therefore, what remains is the respondent number 8 and the petitioner. Who stop. Considering the report which is already available, this court, without expressing anything on merit, is of the considered view that the respondent authorities in the Public Works Department should revisit the seniority list dated 2014, taking into account the report submitted by the executive engineer on 10/4/2015, bracket annexure R. Stop. It is also provided herein that in considering the said report and taking a fresh decision, the respondent authorities before taking any fresh decision shall give due opportunity to the respondent number 8 and the petitioner, apart from any other persons to be affected. Stop. The entire exercise of such consideration be done within a period of 3 months. 60 days. You're in a hurry. You're retiring or what? Then within a period of, okay, 60 days from the date of receipt of a certified copy of this order, writ petition stands disposed of.
Item 9.
You are alone. Yes. Okay. You're saying they already got the relief. What do you say? Then Mr. Shamo's name is shown. What to do then? Next week? Please write down on 3/12/2024. Learned counsel for the petitioner was given time to seek instructions as to whether the prayer made in the writ petition has been redressed. So, however, today as Mr. A. Chamua, learned counsel for the petitioner, is said to be on legs in a different court, the same cannot be ascertained. Stop in view of above, let the matter be listed again. When shall we have it? Be listed again on 26th, okay, 26th of June. Any difficulty? Any difficulty? When? So let's have it on Monday then. Monday? No. Monday is 23rd. You just inform him also. You just have to inform whether relief has been given or not. If not given, then we'll have to proceed and hear the matter. List the matter again on 23rd of June. I'm sorry, sorry. We are in May. Listed again on 2nd of June. Yes.
Item 10.
None appears for the petitioner when the matter is called. Matter stands adjourned for 2 weeks. Same order, Dr. Meera.